right, so for today's case, we'll be discussing the case of Daniel Rivas-Villegas versus Ramon Cortesluna from the United States Supreme Court. And this is a per curiam decision, so that means there is no listed author, and it's issued in the name of the court. Petitioner Daniel Rivas-Villegas, a police officer in Union City, California, responded to a 911 call reporting that a woman and her 2 children were barricaded in a room for fear that the respondent, Ramon Cortesluna, the woman's boyfriend, was going to hurt them. After confirming the family had no way of escaping the house, Rivas-Villegas and other officer presented command to Cortesluna outside and onto the ground. Officers saw a knife in Cortesluna's left pocket. While Rivas-Villegas and another officer were in the process of removing the knife and handcuffing Cortesluna, Rivas-Villegas briefly placed his knee on the left side of his back, later sued excess force. All right, so we have a basic fact scenario here. We've got a police officer in the state of conducting an arrest. We've got a guy who is threatening some people. He's ordered outside by the police. He has a knife in his pocket. And while in the process of removing the knife from the pocket and handcuffing the suspect, the officer, in the course of this, briefly places his knee onto his back. So we're going to try to sue for excessive force. Okay, so let's see if that makes any sense. At issue here is whether Rivas-Villegas is entitled to qualified immunity because he did not violate clearly established law. The undisputed facts are as follows. A 911 operator received a call from a crying 12-year-old girl reporting that she, her mother, and a 15-year-old sister had shut themselves into a room at their home because of the mother's boyfriend. Cortesluna was trying to hurt them and had a chainsaw. That sounds like a threat to me. The girl told the operator that Cortesluna was always drinking, had anger issues, and was really mad, and was using a chainsaw to break something in the house. As we're trying to determine what is and is not excess force, of course, what matters quite a lot is what's in the mind of the officer. What does the officer know and what doesn't he know? And what can he rely on and what doesn't he rely on? Before we can even get to questions like qualified immunity, we have to first determine the officer's mindset and what they do know and what they don't know. So it seems like what the officer here knows is that this person has a chainsaw and is behaving in a way that seems very aggressive to other members of the household. So he is a threat, a clear and present danger, one might say. So that's probably going to dictate quite a lot of the actions that are going to incur as a result of this. A police dispatcher will relay this information along with the description of the suspect in the request for the officers to respond. So the officers know all that. Great. Rivas-Villegas heard the broadcast and responded to the scene along with 4 other officers. The officers spent several minutes observing the home and reported seeing through the window a man matching Cortesluna's description. One officer asked whether the girl and his family could exit the house. Dispatch responded that they were unable to get out and confirmed the 911 operator had heard sawing in the background and thought that Cortesluna might be trying to saw down the door. Again, this is going to go to a lot to the officer's actions and the legitimacy of thereof too. After receiving this information, Rivas-Villegas knocked on the door and stated loudly, "Police department, come to the front door. Union City Police, come to the front door." Another officer yelled, "He's coming," and has a weapon. A different officer then stated, "Use less lethal," referring to a beanbag shotgun. When Rivas-Villegas ordered Cortesluna to drop it, Cortesluna dropped the weapon, later identified as a metal tool. Rivas-Villegas then commanded, "Come out, put your hands up, walk towards me." Cortesluna put his hands up and Rivas-Villegas told him to keep coming. As Cortesluna walked out of the house and towards the officer, Rivas-Villegas said, "Stop, get on your knees." Plaintiff stopped 10 to 11 feet from the officers. Another officer then saw a knife sticking out from a front left porch onto Cortesluna's pants and shouted, "He has a knife in his left pocket, knife in his pocket," and directed Cortesluna, "Don't put your hands down. Hands up." Cortesluna turned his head towards the instructing officer, but then lowered his head and hands in contravention of the officer's order. Another officer twice shot Cortesluna with a beanbag round from the shotgun, once in the lower stomach and once in the left hip. After the second shot, Cortesluna raised his hands over his head. The officer shouted for him to get down. Another officer stated, "Left pocket, he's got a knife." Rivas-Villegas then straddled Cortesluna. He placed his right foot on the ground next to Cortesluna's right side with his right leg bent at the knee. He placed his left knee on the left side of Cortesluna's back, near where Cortesluna had the knife in his pocket. He raised both of Cortesluna's arms behind his back. Rivas-Villegas was in this position for no more than 8 seconds before standing up while continuing to hold his arms. This sounds like reasonable force. Again, reasonable force is determined by the fact-specific scenarios. It depends. What does the officer know? What doesn't he know? What is the situation? How is the situation evolving? How is the situation changing? And what might be reasonable one moment is not necessarily reasonable the next moment, because obviously the facts are changing. But in this particular factual posture, it seems like the officer is acting fairly reasonably. The officer is confronting someone who has a weapon, has so far refused commands, has been shot by less lethal devices, and has now been put down on the ground, and in part of the arresting procedure, puts his knee on his back for 8 seconds in the course of conducting the arrest. This seems very, very reasonable and not to be a problem in terms of a excessive force. Of course, if it had gone on for 80 seconds or 800 seconds, that might be a very different posture, but that's not the posture we're in. What matters are the facts that are relevant to this case. At that point, another officer who just removed the knife from Corteluna's pocket and tossed it away came in handcuffed Corteluna's hands behind his back. Rivas-Villegas lifted Corteluna up and moved him away from the door. Corteluna brought suit under 42 U.S.C. 1983, claiming excessive force in violation of the Fourth Amendment. This sounds like proportional force. And even if not, it's not something that's clearly a violation. The district court grants summary judgment to the officer, but the Ninth Circuit over here somehow reversed. So, yeah, that doesn't sound like... Whatever the line for qualified immunity should be, assuming it should exist at all, then this is not it. And even if we abolished qualified immunity and we went back to the old standards, this still wouldn't be a violation. Right? If we went back to before the idea of qualified immunity and we went back just to the pure concept of what would a reasonable officer do in this situation, the reasonable man test is kind of the alternative to qualified immunity. What would a reasonably prudent person do in this situation, right? So even if we abolish qualified immunity, it wouldn't help. So this is definitely not the case to do any of those things. This is what we call in law a bad vehicle to do something. So even if you were inclined to reverse qualified immunity, this is a bad case to do it in. It's a bad vehicle for that because the facts don't really lend themselves to that kind of a conclusion. So it's not particularly a wonder, therefore, it's a per cram decision because the Supreme Court's going to just be like, no, what are you talking about? This doesn't make any sense. The Ninth Circuit is off their rocker, which, not for the first time. The Court of Appeals of the Ninth Circuit held that Rivas-Villegas is not entitled to qualified immunity because existing precedent puts him on notice the conduct constituted excessive force. Really? In reaching this conclusion, the Court of Appeals relies solely on Lalonde versus County of Riverside. The court acknowledged the officers here responded to a more volatile situation than in Lalonde. It's going to be fact-specific. Reasonable force is dictated by the situation. Nevertheless, it reasoned both Lalonde and this case involve suspects who were lying face down on the ground and who were not resisting either physically or verbally, on whose back the defendant officer leaned with a knee, causing alleged significant injury. But it's for 8 seconds, though. Right? This is quite a different fact pattern than other ones we've seen. The amount of time, what the officer knows, what they don't know, their ability to perceive, and so forth and so on, is quite different than in other notable cases. Judge Collins dissented. As relevant, he argued the facts of Lalonde are materially distinguishable. I would think so. And therefore insufficient to make clear to every reasonable officer the force used was excessive, which also implies the force was excessive, which also is not clear. So you have a couple different problems. Is the force excessive in some sort of absolute sense is one question. Then if we're on qualified immunity, is it clearly established? And even if we're not doing qualified immunity, if we want to abolish that, what would a reasonable officer perceive in this situation? Going back to the old standard. So it's like, no matter how you slice it, it doesn't seem like it gets you to the end of the page. We agree and therefore reverse. Even assuming that controlling circuit precedent clearly establishes law, for the purposes of 1983, Lalonde did not give fair notice. He's therefore entitled to qualified immunity. This is a bad case to try to reverse qualified immunity on. Qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. A right is clearly established when it's sufficiently clear that every reasonable official would have understood what he's doing violates that right. Although this court's case law does not require a case to be directly on point for the right to be clearly established, and although it's true it doesn't have to be directly on point, the overall thrust of the case law is it has to be really, really close. Really close. Existing precedent must be placed seeing the question beyond debate. This inquiry must be taken in light of the specific context of the case, not as a broad proposition. Again, when they say not as a broad proposition, they really mean it. You have to find something that is very, very close to overcome qualified immunity, which may be a reason to overturn qualified immunity, but not on the basis of this case. Specificity is especially important in the Fourth Amendment context, where it is sometimes difficult for an officer to determine how relevant legal doctrine, here excessive force, will apply to the factual situation. We're all, of course, assuming this is excessive force, which, again, given the description of the situation, does not at least seem readily apparent. Whether an officer has used excessive force depends on the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officer or others, and whether he's actively resisting or attempting to evade arrest. He had a chainsaw and was trying to chainsaw down the door with people involved. He might be a bit of a danger, even if the chainsaw is no longer in his hands. Seems like he might be a bit of a volatile guy. The Graham and Gardner standards, which are classics in this domain, are cast at high levels of generality. In an obvious case, these standards can be clearly established law, even without a body of relevant case law. But this is not an obvious case. It's not even close. Thus, to show a violation of clearly established law, Cortesluna must identify a case that put Rivas-Villegas on notice his conduct was unlawful. Cortesluna has not done so. Neither Cortesluna nor the Court of Appeals identified any Supreme Court case that addressed facts like the one at issue here. Instead, the Court of Appeals relied solely on its precedent in Lalonde. Even assuming the circuit precedent can clearly be established law for the purposes of 1983, Lalonde is materially distinguishable and does not govern the facts of this case. In Lalonde, the officers were responding to a neighborhood complaint that Lalonde had been making too much noise in his apartment. When they knocked on Lalonde's door, he appeared in his underwear and t-shirt, holding a sandwich in hand. Awesome. Lalonde testified that after he refused to let the officers enter his home, they did so anyway and informed him he would be arrested for obstruction of justice. That is not obstruction of justice, by the way, although a lot of officers seem to think it is. One of the officers then knocked the sandwich from Lalonde's hand and grabbed Lalonde by his ponytail and knocked him backwards to the ground. This sounds very like excessive force. Them refusing the police to come into your home is not obstruction. You have a Fourth Amendment right. After a short scuffle, the officer sprayed Lalonde in the face with pepper spray. At that point, Lalonde ceased resisting. Another officer, while handcuffing Lalonde, deliberately dug his knee into Lalonde's back with force that caused him long-term, if not permanent, injury. That sounds a lot different from this current fact pattern. So even if you think Lalonde is excessive force, which it sounds a lot like it is, not for at least the reasons that Lalonde wasn't doing anything illegal by refusing the police's entry. So their behavior was completely disproportionate. So even if you think that was, this is not. These are two very different cases. The situation in Lalonde and the situation at issue here diverge in several respects. In Lalonde, officers were responding to a mere noise complaint, whereas here they're responding to a serious alleged incident of domestic violence, possibly involving a chainsaw. In addition, Lalonde was armed. In addition, Lalonde was unarmed. Cortesluna, in contrast, had a knife protruding from his left pocket for which he had just appeared to reach. Further, in this case, video evidence shows, and Cortesluna does not dispute, that Rivas-Villegas placed his knee on Cortesluna for no more than 8 seconds and only on the side of his back near a knife that officers were in the process of retrieving. Lalonde, in contrast, testified the officer deliberately dug his knee into his back where he had no weapon and made no threat when approached by police. These facts, considered together in context of the particular arrest, materially distinguish the facts from Lalonde. Cortesluna, in contrast, had a knife protruding from his left pocket, for which he had just previously appeared to reach. Further in this case, video evidence shows, and Cortesluna does not dispute, that Rivas-Villegas placed his knee on Cortesluna for no more than 8 seconds, and only on the side of his back, near the knife the officers were in the process of retrieving. Lalonde, in contrast, testified that an officer deliberately dug his knee into his back when he had no weapon and made no threat when approached by the police. These facts, considered together in the context of the particular arrest, materially distinguish the case from Lalonde. Precedent involving similar facts can help move a case beyond otherwise hazy borders between excessive and acceptable force, and thereby provide an officer notice that a specific use of force is unlawful. On the facts of this case, neither Lalonde nor a decision of this court is sufficiently similar. For that reason, we grant Rivas-Villegas petition for certiorari and reverse the Ninth Circuit determination that Rivas-Villegas is not entitled to qualified immunity. Thus, that brings us to the end of the case of Daniel Rivas-Villegas versus Ramon Cortesluna. In this case, we learned an officer responding to a threat of a person who had tried to hack up people with a chainsaw, put a knee on someone's back for 8 seconds while trying to remove a knife from the guy's pocket. The Ninth Circuit apparently found this to be excessive force and also clearly established by the case law. Now, I dispute all those things. I'm not a big fan of qualified immunity, as anyone on this channel knows. I think it's a problematic doctrine, not for at least the reasons that the circuit courts never clearly established the law. If they clearly established the law, it wouldn't be so bad, but most of the time they avoid it. So it winds up being basically something that's very, very difficult. But for whatever criticisms I have of qualified immunity, this is a bad case to try to reverse it on. Because it's not even clear that even without qualified immunity, he'd be liable. Because then we're just back to the reasonable officer test, which is just the reasonable man test. What would a reasonable person do given what they know? And here this seems very reasonable and proportionate to the force. So it's not a big surprise that they lost the case, and that brings us to the end of the consideration of this case.